now we'll record the loud and clear. Okay, good. So we'll start the lecture now for today's lesson. We'll cover the second part of lesson 6, chapter 6. It's called Interpretation of Legislation. Because the interpretation of legislation is a quite difficult topic. I don't know why the video does not work today. Oh, sorry. So you cannot see me. I don't know why. Oh yeah, no, good. Now you can see me. For this topic, I think is something quite difficult. Very difficult. Why? Because usually not so many people have the concept of interpretation of legislation. Because most people think that for legislation, for ordinance, they're already clearly written. They're in black and white, so the meaning should be very clear. It may not be the case. Because later on I will show you many examples to so that you know legislation sometimes we have ambiguity and also uncertainty. So we have to spend the whole lesson on this very difficult topic. And also this one usually is a hard question in the examination. You can expect nearly all the examination will have a question on interpretation of legislation. So in Chinese, it's 6法. So usually we know this term. For interpretation of the basic law by the National People's Congress Standing Committee. But in fact, the court always interpret the legislation. It's usually the job of the court under the common law system. Usually it's the job of the court. Okay? Because the court will refer to a lot of precedent in order to interpret the legislation. Now we'll go to say the PowerPoint. So we have two major parts of this chapter, making of legislation, which has already been covered in the last lesson. Because making of legislation is something so mechanical, so straightforward, so we don't need too much explanation. And now we may proceed to slide 9. So we'll start with interpretation of legislation. So first of all, who does the job of interpretation of legislation? First of all, why do we need to interpret legislation? Don't expect the law will provide for everything. It's not possible. There are simply so many different scenarios. It's not possible to foresee all different sets of facts which may arise. So when you study contract law, you know everything may change. The facts may change, the party may change, so the circumstances may change, the sequence of events, so the conduct, the statement, different people will use different statements. Okay? You can only give a general definition. For example, intimidation, theft, undue influence, you can only give a definition. Sometimes you can use cases to illustrate the legal principle, but you cannot list out all the possible situations. It's not something possible. First of all, who interprets statute A, B, C, and D? Do the answer. Who will do the job? Is it the Chief Executive, Secretary of Justice, judges, or lawyer? Who will do the job? A, B, C, and D. Very good. It should be C. Everyone knows that it should be the job of C. Judges. Why? Because judges, he's a legal professional, and also he is neutral, fair-minded. So it's the reason why he should interpret the law. Okay? For Chief Executive, he's the head of the executive. For Secretary of Justice, he is the legal advisor to the government. For lawyer, the legal advisor to the client. So the job must be done by the judge. Okay? But don't expect so the judge will answer your question. If you send me email, I will answer your question. So if you have some query in the legislation, you do not quite understand the meaning of Section 5 of the Company Ordinance, can you send an email to the judge? Of course you can, but usually he will never answer your question. Okay? Why? Because the judge will only interpret legislation when there's a case before him. You have to bring a case to the court. You have to take a legal action in the court before the judge will answer your question. Okay? So the formal definition of statutory interpretation or legislative interpretation is the process by which the court determines the meaning of the statutory provision. For example, a certain section, regulation, bylaw, etc. Collectively, we call it statutory provision. And also the key point is for the purpose of the situation before them. Okay? That means that there must be a real case. There must be a real case. Okay? So the court will not do the job when there's only a hypothetical case. For example, if you ask the judge if someone come to Hong Kong without any permission, we will be allowed to stay in Hong Kong. So if you ask this kind of question, he will never answer your question. Okay? So if such a case really happen, and someone bring the case to the court will do the job. But if you just use a hypothetical case, so if you ask even the government will not answer the question. So one of the very usual statement by the government is that the government will not respond to any hypothetical case. For example, if the reporter say, if so and so, what will the government do? If something happens, what will the government do? Usually the government will say, we will not answer any hypothetical case. Okay? So judge is also the same. Don't expect he will answer your question. Okay? So he will only do the job or interpretation or legislation when there's a real case before the court. There must be a real case before the court. Okay? Of course, you can ask a lawyer, but you cannot ask a judge. Also, why is first of all we have to know why interpretation of law is so important. First of all, we have to distinguish substantive and also interpretive legal action. Substantive issue means issue relating to substantive law. For example, in contract law, all the issues are substantive law. All the issues are substantive legal issues. Because substantive legal issue means legal issue relating to substantive law. In chapter 2, we have learned one of the classification is substantive law versus procedural law. For the actual duties and rights of the party is called substantive law. For example, like contract law, tort law, company law. Usually they are substantive law. So for those issues, they are the usual issue in the court. But some issue are relating to interpretation. So it's called interpretive legal issue. So it means that the legal issue is something in relation to interpretation of legislation. Legal position may depend on the meaning of one or more statutory provision. For example, if I say that if you carry on the business of lending money, you need a license. So what is meant by carrying on the business? If you lend money to your friend, does it mean that it's a carry on business? So we have to know the actual meaning of carry on business. Okay? So the meaning will affect your legal position. The legal position will depend on the meaning of carry on business. Okay? So you may be guilty or not guilty because of the definition of carry on business. So we call it interpretive legal issue. It will affect the legal position. It will affect whether someone will be guilty or not guilty, someone will be liable or not liable. So we go to an example on page 105. Now please go to page 105 of the workbook. So it should be 104. 104. The case Attorney General. Attorney General is equivalent to the Secretary of Justice. Because we have changed the name. In the past, we have the Legal Department. Now it's the Department of Justice. The head of the Legal Department was called Attorney General, 律政司. Okay, 律政. But now it's called the Secretary for Justice, 律政司司長. So we have changed the name, English name, and also Chinese name after 1997. So in fact, it means the government. When we use the term Attorney General or DOJ, usually it means the government. So there was a case between the government and a company called Harvard Engineering Company Limited. So in this case, the defendant was a contractor responsible for some engineering work to locate and remove a blockage, etc. So there was an explosion. So someone was hurt, and so 3 employees were injured. So the defendant was charged under a regulation of the construction site safety regulation because there was an accident and the defendant should be responsible. So he was charged with failing to take such measure to prevent the worker from being endangered. Okay? So for this one, so whether the defendant was guilty, it depends on what. The substantive issue in legal issue in this case was whether the defendant was guilty of offense under the regulation. The regulation provides that so when there was a worker working in the construction site, the contractor responsible so should take such measure to prevent them from being endangered by the cable or apparatus. But the key point, the issue is what is the meaning of construction site? Okay? Whether the whether the defendant would be guilty, it depends on the definition, the meaning of construction site. If the accident happened in the construction site, the defendant will be guilty. If the accident did not happen in a construction site, the defendant will be found not guilty. So whether the defendant was guilty or not depends on the meaning, depends on the definition of the construction site. For the definition, usually we will, later I will show you. In Ordinance, so usually in Section 2, we have the definition section. You can find a lot of definition. So for many terms, they are defined in Section 2 of the respective ordinance. Okay, so you should go to Section 2 to find whether this term is defined, what's the definition of this term. Okay. So sometimes you can find the definition in Chapter 1 of the laws of Hong Kong. So it's called Interpretation and General Clauses Ordinance. Later I will show you. Okay. So for that, when someone was charged with possession of dangerous weapon, so whether he will be guilty, it depends on the meaning of dangerous or dangerous weapon. 危險嘅武器。Okay. So how can we find the the meaning of the term construction site? So Regulation 2 defines construction site as a place where construction work is undertaken, and also any area in the immediate vicinity. The legal issue was whether the worker were engaged in construction work at the time of the accident. So we cannot just designate some area to be construction site. So we define construction site as a place where construction work is undertaken. Okay. But the meaning of construction site will depend on the meaning of construction work. Whether the worker will engage in construction work will affect the outcome. Whether the site was defined as a construction site depends on what? Depends on whether the worker will engage in construction work. So we have to look at the meaning of construction work. Since Section Regulation 2 did not define construction work, there was a doubt as to the meaning of the term. If the worker were not doing any construction work, the site will not be regarded as a construction site, and the defendant will be found not guilty. Okay, so it's the mechanism. So whether the defendant will be found guilty depends on the meaning of construction site. The meaning of construction site depends on the meaning of construction work. If the worker will not doing any construction work, the site will not be regarded as a construction site, and the defendant will be found not guilty. Okay? So substantive legal issue is whether the defendant is guilty of an offense under the regulation. The interpretation issue is whether the workmen were employed at a construction site. Okay, so sources of doubt. So we have two major ones. The first one is ambiguity and also uncertainty. For ambiguity, it means that sometimes the meaning is not so clear. Okay, sometimes people use the same term, but the meaning is not clear. One of the reasons is that many terms they have more than one meaning. So we'll do the activity first, and then we go to the gag. I will marry you. First of all, for vessel, for house, for marriage, sometimes we may not know the meaning you are talking about. For vessel, it may mean a craft or container. House, it means the home we live. So if you go to a foreign country, you want to buy a detached house or at least a semi-detached house. So you can buy a house so easily when you go to England. It also means a governing body. For example, a House of Law, a House of Commons, and also in many secondary schools we have different houses: the yellow house, the white house, the blue house. Okay, so marriage is also the same. Sometimes it means ceremony or marriage, and also sometimes it means status or being married. So many terms. They have two different meanings. The meaning of words or phrases is often unclear. So these are the two sources of doubt in legislation. Ambiguity. Ambiguity means it's because a verb or phrase is capable of having more than one meaning. So it's the reason why the word must be interpreted. We have to choose which meaning we are talking about, we are referring to. Uncertainty means whether the provision apply to the fact before the court. The meaning is quite clear, but we do not know whether this regulation can be applied in this situation. Okay? But it's not certain that the legislature intended the law to apply to the particular fact of the case. The word must be applied to the fact. So application. So when you study contract law, you know application is something most important. To some people, application is most important. Why? Because from time to time you only have the definition of some legal concept, some legal rules. But your job is you have to apply what you have learned to the actual situation you encounter. Because usually the question is a problem type question. So you have a problem, you have a fact pattern. You have to apply the law to solve the problem. Sometimes application is difficult. For some students, they can memorize so many things. They can memorize the case name, they can memorize the section number, but they find it difficult to apply. Just like investment. You know all the rules. Okay? You know all the rules for investment. The teacher will tell you when you should buy, when you should sell, but you find it difficult to apply. You find it difficult to judge. What's the right time to buy? What's the right time to sell? It's the most difficult one. Now we go back to the gag. So I prepare a gag. The gag is called "I Will Marry You." Okay. So please look at the gag. This is a real story. It's not a hypothetical case. It's a real story. So I met a middle-aged man in England when I was studying there so many years ago. So we had a conversation one day. So the middle-aged man said, "I will marry you." You or me, what will be your response? If a middle-aged man say, "I will marry you," so what will you do? So what is your response? When a middle-aged man, I will not marry a man. Chen. Low how much money you got? Are you serious? Low, thank you. Low, thank you. It's a real story. It really happened to me. So I try to guess my response. Of course, these are the possible response. Great, when, low, hey, oh my God. How much money you are willing to pay? I may respond, quite surprised, but remain silent. Of course, you have to know the context under which the gentleman say this word. So if you know the context, of course, you will know what it actually means. I was very glad that I did not say anything. The middle-aged man was a Pierce, Reverend Mosley. Okay, Reverend Mosley. The context. He said such thing when we were in a council meeting before the wedding. Because I got married in England. So I have my wedding in England. I have my wedding in church. So usually before the wedding, there will be a council meeting. So the reverend, the peers will conduct the council meeting. When he said, I will marry you, I was a little bit surprised. I did not quite understand what he actually means. In fact, when I go back home, I go to find a dictionary, the meaning of the word marry. So one of the less common meaning is joy as husband or wife. For example, which peers, which officer, which civil servant is going to marry them. To marry you means to officiate the wedding ceremony. 主持婚禮咁解it means he will officiate the wedding ceremony. 即係佢會主持婚禮，就唔係揾第二個去做。Okay? So he will officiate the wedding. Okay? So instead of he will get married with me. Okay? So if I say, oh no, I won't get married with a man. Of course, it will be something too funny. Of course, I was very careful at that time. I did not say such word, otherwise it would be so embarrassing. And also, do you want to see Reverend Mosley? This Reverend Mosley, this one, this is me. When I got married, this is my wife. She's my wife. So see what see the difference. So the time when I was married, and also the time what I look like in the year of 2014. 25 years after the wedding. Still more or less the same. Hopefully. All right. So it's a real story. It's not a hypothetical case. So it's a real story. From time to time, sometimes we do not quite understand the meaning. Because for people in Hong Kong, usually we only know the most common meaning of a term. So a term may have so many different meanings. Okay? So there may be some meaning which are not so common. So we have to be very careful. Otherwise, there will be embarrassment. One of the and also in Hong Kong, one of the difficulty is one of the problem of interpretation of legislation is the legislation in Hong Kong is expressed in two languages, in English language and also Chinese language. In the past, the Chinese version was only the translation version. So I recorded when I was a small boy. Usually for many Chinese version, Chinese legal document. There's a wording to say that it's only a translation version. If there's any conflict between the Chinese version and English version, the English version will be followed. The English version will prevail. It's something unavoidable because most of the legal documents are drafted in English and then they will be translated into Chinese. And also sometimes Chinese is quite I think we don't have the same concept in our language. So if you study law in Chinese, sometimes it will be very difficult for you to know the meaning of those terms. This is the reason why you should study law in English instead of in Chinese. Chinese is only for reference purpose, according to my concept. Right? Because there are so many terms. The Chinese version, in fact, it's not the real. It cannot reflect the true meaning of the English term. But the point is that so in our system, we always emphasize that both the Chinese version and also the English version are authentic text. The Chinese version 係真確本嘅 authentic text. So it's not the translation text. It's not the translation version. It's not only for reference. It's authentic. Okay. It means that it can be relied upon. So section 10 capital B, subsection 2 of the Interpretation and General Clauses Ordinance. This one is called IGCO Cap 1. Please note that this chapter, this legislation, this ordinance is unique in Hong Kong. You cannot find a similar ordinance in other countries. You cannot find it in UK. You cannot find it in US. It's something very unique. Why? Because when Hong Kong became the colony of UK, so they find it's something necessary. They want to define so many things. They want to say the British people wanted to include many interpreting section in the ordinance. So many terms are defined in the ordinance. Okay? So one of the sections, section 10 capital B, say subsection 2, presume that the two texts, that's the English text and Chinese text, have the same meaning in law. Okay? Subsection 3 implies that in the event of difference, the two texts should be reconciled. Reconcile is a useful term in legal study. In the LB program, usually we will say we always use this term, reconcile. Reconcile means that you have to argue that they are not in conflict. Okay, so sometimes the lecturer will give you two statements. The two statements seem to be in conflict. So your job is to reconcile these two statements. Reconcile means that you have to argue that they are not in conflict. So it's the meaning of reconcile. So expression of the common law in English version shall be construed in accordance with the common law meaning. And so I can show you, say, the section, the ordinance. Okay. So please now we go to chapter 1. Chapter 1 is called Interpretation and General Clauses Ordinance. 釋義及通則條例. Okay. In Chinese, it's called 釋義. Okay. And also 通則條例. So the purpose of this ordinance is to define so many things. You can find a lot of definition and also a lot of general clauses. For example, section 5 say that grammatical variation and coinage expression. If you make a grammatical mistake, usually it will not affect the meaning of the term. And also gender. So no need to say he or she. He will include she. She will also include she. She will also include he. Well, expression importing the masculine gender include the feminine gender and neuter gender. So singular will include the plural. Plural will also include the singular. So you can make use of this section to solve some problem in grammar. So many things are well defined in this ordinance. So this one is quite useful. Many lawyers from England, they do not know. We have the chapter 1. Sometimes we call it cap 1. And also you have to know the importance of context. Now I think we have to jump to slide 25. Because is the order in the workbook may not be so good. I think we have to say, we have to cover the different approaches in interpretation of legislation first. Please now go to slide 23. And I will go back after we have discussed all the different approaches to statutory interpretation. Okay, please note that The court does not only have one way to interpret the legislation. Altogether, we have several approaches. In the common law, we have 4 different approaches to statutory interpretation. But before that, so we have to mention section 19 of chapter 1. This is a reproduction of chapter 19. So I'll give you 1 minute's time. Please go through it. I'll see whether you can understand this section. You have to learn how to understand a section in the legislation. Okay. So for this one, ordinance shall be deemed to be remedial. This one is very meaningful. Can you guess what's meant by remedial? Why we say remedial? 補救性. Why we say ordinance is remedial? Do you know the reason? The reason is is remedying the defect of common law. Please note that most of the ordinance, so they are going to cover the defect of common law. Okay, because at the very beginning, we only have common law. The common law system only have common law. But later on, as people find the common law have a lot of defect, a lot of shortcoming. But you simply cannot ask the judge to change. Because if you ask the judge to change, it will be say no interference with the judiciary. So what can the government do? The government can only pass legislation to remedy the defect of common law. Okay? So is the meaning, is the reason why we say an ordinance is remedial. 補救性補救 common law 嘅不足。And so we receive such fair, large, and liberal construction. Because construction does not mean constructing a building. 唔係解建築。It means construction is the noun of construe. It means interpret. So it means to means interpretation or explaining. So you have to interpret the law in a fair, large, and liberal way. So you have to use a broad approach. Don't just confine yourself to the wording. Okay, you have to as will best ensure the attainment of the object. You have to consider the object of the ordinance. So you should not just look at the wording. You have to consider the object. The object means the purpose of the ordinance. For example, the ordinance is about prohibition of smoking in the public area. So it's the object of the ordinance. So when you are interpreting the section, you have to know the purpose, the objective of the ordinance according to its true intent, meaning, and also spirit. So you should not just confine yourself to the wording. So the listing rule also have the same wording. So if you go to see the listing rule of the stock exchange, they also have the same wording or similar wording. So you should not just confine yourself to the wording. You have to look at the objective, intent, and also the spirit of the legislation. So section 19 apply unless there's a contrary intention in the legislation. Section 19 may be regarded as the first principle of interpretation. So in your answer, when you are answering question on interpretation of legislation, don't omit section 19 of chapter 1. Okay? So you have to mention it. Even though in fact it's not something so meaningful. So for the court, for the judge, usually they will still use the 4 different common law approach. Altogether, we have 4 different approach under common law. They are still being used by the judge, despite we have section 19. It does not mean that judges cannot use other approaches to interpretation. But the meaning of section 19 is quite unclear, and judges continue to use the common law approaches to interpretation. Now we will go through the 4 different approaches. These are the 4 different common law approaches to interpretation. In fact, it can be grouped into 2 categories. Literal rule is the first category. For mystery rule, golden rule, and also purpose approach, they can be classified as the second category. The major difference is that literal rule look at the wording of the legislation. It look at the wording. So it just look at the literal meaning of the wording, right? So for this fee, they look at the purpose, the intent, the spirit of the legislation. They look at the intention behind, the purpose behind. They do not just look at the wording. But of course, they have 3 different emphasis, but they can be grouped together. These 3 based on them, mystery rule, golden rule, purposive approach. They are quite similar. Sometimes it's difficult to distinguish them because they do not just look at the wording. They look at the purpose, intention, objective behind the legislation. So these are the 2 different broad categories. This one look at the wording, the literal meaning of the legislation. This one look at the purpose behind. Okay, so we can go through them one by one. So the first one is called literal approach. 字面法規. So literal meaning. The literal. So from time to time, we use the term literal meaning. Literal meaning. Okay? For example, we say there are so many meanings. For example, also when we say apple, the literal meaning of apple, of course, is the the apple we eat. The apple and orange. So this is the food we eat all the time. It's called the apple. But apple may have some other meaning. Apple of the eye. Apple of my eye is someone I like so much. So it's another meaning of apple. Okay. So when we use the literal approach, usually we just it only means the apple we eat. But there may be some other meaning. The literal approach is also called the grammatical approach because it looks at the verbs and verbal expression of the statute and nothing else to see if there's any ambiguity. So the requirement for literal approach is that there should be low ambiguity. The wordings are quite clear. So the meaning is very clear. When the meaning is clear, there's no need to use other approach. Usually the judge will use the literal approach when the meaning is clear. Of course, the judge has to decide whether the meaning is clear. If the meaning is clear, they just use the literal approach. If there's no ambiguity, the word used must be given the ordinary and natural meaning, even if this leads to absurdity. Sometimes the result may be a little bit unreasonable, but it doesn't really matter, right? Still, the court will use the literal approach if there's no ambiguity. For ordinary word, they will be given the ordinary meaning. For technical word, like some professional jargon, they must be given the technical meaning. It can be illustrated by a case called HKSAR and S-Spade design. Okay, this company has nothing to do with spade. Okay, so it's only the name of a company. So in fact, the company was an employer. There was a dispute between the employer and the employee. For this dispute, it's about termination of employment contract. So I think all of you, most of you are employees, so you should be quite familiar with the law relating to termination of employment. For employment, mainly it can be terminated by 2 major ways. The first one is under Section 6, termination by notice. Usually when you get a new job. So many people they are looking for a new job. So usually they will get a high salary. Once they have got a new job, usually what will they do? They will resign. When they resign, usually you have to serve a notice. So according to the length of the notice will be in accordance with your employment contract or employment letter. Sometimes most people are 1 month. Some more senior people may be 3 months. Some may be even 6 months. It depends on the terms of the contract. Okay? So if the notice is only 1 month, so you serve a 1 month notice and then you can leave your company, you can join the new company. This is called termination of notice. So of course, both parties, both the employer and employee can terminate the employment by notice. The employer can also serve you 1 month notice, right? But of course, the employer seldom do so. Why? Because we also have Section 7. Section 7 is called termination by payment in lieu of. Please note that in lieu of is Latin. It means instead of. 代通知金okay? The formal Chinese term is 代通知金. Most people call it compensation, but in fact, the proper term is called payment in lieu of notice. It means that you don't want to serve notice. Okay? You pay money to replace the notice. For example, so you have to serve 1 month's notice, but you're in a hurry, so you have a very good job, the salary is double, so you want to leave as quickly as possible. Instead of serving a 1 month notice, you pay 1 month salary to the company. So it's called payment in lieu of notice. Okay? But practically speaking, for employee, usually which one would they choose? Will they choose notice or payment in lieu of notice? Most of the employee. Most of the employee, which one they will choose? Notice or payment in lieu of notice? Yeah, very good. Usually it's notice. Most employee will choose serving a notice. Why? Because after you have served the notice, you don't need to do anything. You leave everything to your colleagues or to your boss. So you can have the salary and also you have a peace of mind during the 1 month period. Okay? But how about employer? Most of the employer they will choose payment in lieu of notice. Why? Because if you serve a notice, when you say, "Oh, David, work in the company for 1 more month and then you have to leave," it will be very dangerous. Why? Because the employee will disrupt everything. He will cause a lot of trouble to the employer. So many employers usually they will ask the employee to leave immediately. Sometimes some companies even send a guard to supervise the employee in say wrapping up the own sale the private belonging. Okay? Because the employer is so worried, the employee will do something wrong. For example, disrupting the computer system or say send a very bad email to the public, etc. So it will cause a lot of damage to the company. So it's the reason for employer they seldom use any notice. Instead they will use Section 7. So payment in lieu of notice. Right? But in this case, the employee was pregnant. Everyone knows that for pregnant employee, they will be entitled to the maternity leave. Most people know that once the employee was pregnant, do you think the employer can terminate the employment? Do you think the employer can terminate the employment when he knows that the employee was pregnant? Most people say that it should be low. The employer should not be entitled, should not be allowed to do so. So because we have to protect the pregnant employee. Because the employee, the female employee, the pregnant employee, will enjoy a maternity leave around 10 weeks. 10 weeks of maternity leave. So usually the employer will suffer some loss. Some of the employees they try to terminate the employment. Okay? So it will be, he may be punished by the government. The government will prosecute him because the employee will report the case to the Labor Department. The Labor Department may prosecute the employee. Right? So under Section 15, a no employer shall terminate a contract or employment of a female employee under Section 6 or Section 7 after she has given notice of intention to take maternity leave. So it's the wording of Section 15 of the Employment Ordinance. But in this case, the employer summarily 即時解僱we have some kind of dismissal. So it's called summary dismissal. Summary, it means easy. It means immediate. Okay. So we have summary offense. So summary offense usually means simple. It means that there's no need for the employer to serve any notice and to pay any payment in lieu of notice in some under such some circumstances. It's something defined under Sections 9. Altogether, we have 4 grounds for summary dismissal. For example, dishonesty, or say willful disobedience of the duty of the order of the employer, etc. We have 4 different grounds. So for summary dismissal. So the dispute in this case is whether the employer was entitled to terminate the contract or employment under Section 9. Because if you look at the wording of Section 15, the employer is only not allowed to terminate their employment under Section 6 or Section 7. So Section 9 is not mentioned in Section 15. Okay? So the employer will argue that so I'm not allowed to terminate the agreement, the contract under Section 6 or under Section 7. But now I terminate the employment under Section 9. It's not something prohibited by Section 15. Okay? So it's some kind of ambiguity. Okay? So the employer summarily dismissed the employee on the ground that she had not been performing her duty satisfactorily. Usually, after pregnancy, when the female employee was pregnant, she still had to work. Okay, usually she could only enjoy the maternity 6 weeks before the expected pregnancy, the expected day for his giving birth to the baby. Okay, so but can you guess the outcome of the case? Of course, many people were sympathetic towards the female employee. But the court held that the employer was not guilty of an offense because he had not been attempting to dismiss her under Section 6 or 7. Because only Section 6 or 7 are mentioned in Section 15. But instead, he dismissed her under a different provision in Section 9 of the Ordinance. The judge refused to apply the mischief rule, stating that it should only be used to determine the true intention of the legislature. If the words of the legislation were ambiguous or equivocal. Here the words of Section 15 were plain and also unambiguous. The court found that there was no ambiguity in Section 15. This is the reason why the judge used the literal approach instead of the mischief rule. So if the court used the mischief rule, what will be the outcome? Mischief rule means look at the purpose. So can you guess what was the purpose of Section 15? What was the purpose of Section 15? What was the purpose of Section 15? What was the objective? Not to allow employer to terminate staff at any time, or to protect the pregnant female employee, because they will be entitled to the maternity leave. So the many employers, they will prefer to find another person. If the employer can terminate the employment of the pregnant female employee, he can save a lot of money. So he find another worker to do the job, and so he can save a lot of money. So this is the purpose of Section 15. But if the employer can never say terminate the employment, it may also be unfair. Yeah, for example, I'll take an extreme example. If a woman is pregnant and then he does not do any work, so after he has served the notice of pregnancy, so it may also be unfair to the employer. So the law has to strike a balance. So for this section, I think the wordings are quite clear, and so it is not necessary for the court to use the mischief rule. The court can just look at the wording of Section 15, because Section 9 is not mentioned in Section 15. So it's the reason why. So the court held that the employer should not be guilty of this offense. Now we go to the second rule. The second rule is called Golden Rule. Golden Rule, please note that is very funny. Because Golden Rule, the term Golden Rule is used in so many areas. It's not only used in statutory interpretation. It's also used in so many things. 黃金法則 okay. For example, in investment, we also have the Golden Rule. Do you know the Golden Rule of investment? What's the Golden Rule of investment? Very good. Golden Rule of investment. Buy low and sell high. Buy the share at the price of $1 and sell the share at the price of $10. Okay, you can earn a lot of money. But you do not know when the price is low, when the price is high. Low and low. Okay. Sometimes so you think it's very low, but sometimes it will be even lower. 低處未算低so you think the price is already high, it's already $10, you sell the share, and then the price will go up to $20, $30. So it's difficult to judge. So and also the Golden Rule, some people say that the Golden Rule is not to lose any money. 唔好輸錢 okay? Not to lose any money. Even though you cannot earn any money, but at least don't lose any money. Of course, it's also something quite meaningless. If you invest in anything, in any product, there may be a chance that you will lose some money. So for the Golden Rule in interpretation of legislation, so the Golden Rule is that court's duty is to give effect to the intention of the legislature, where the application of the little rule will lead to absurd or repugnant. Absurd or repugnant means very unreasonable, very ridiculous. 好荒謬嘅結果 okay? The focus shift from verb to a broader approach which attempt to find what the legislature intended. So it's the reason why we say little rule is one category. Golden Rule is another category. Why? Because for Golden Rule, the judge will not just look at the wording. The judge will look at the intention of the legislature. It can be illustrated by a case called reciprocal. First of all, we means in relation to 有關於 so it's a very common way in common term in case name. Usually it means the case is in relation to a family. Because many parties they use the same surname. Sickworth is the surname. Many parties, plaintiff, defendant, etc. So they are in the same family. They are family member. They have the same surname. So if you state the name of each party, it will be very redundant. So you better use reciprocal. So it means that so all the parties are in the same family, in the Sickworth family. So what happened? So I can show you clips. Okay. So I can find sometimes when you are reading some English case, I think you can find some very famous English case in YouTube. A key fact. A son had murdered his mother the mother had not made a will. If the mother did not make a will, so the succession, the estate 遺產 right? So would have been inherited by her, her next of kin. Next of kin means the most close family member. According to the rules set out in the legislation. So in Hong Kong or under English law, so anyone can make a will. So if he has made a will, the estate will be distributed in accordance with the will. But if there's no will, so the estate will be distributed according to the legislation. In Hong Kong, so is the we also have a legislation for this purpose. It's called Intestate Estate Ordinance. The law was very simple. There was no ambiguity in the word or the act, but the court held that the literal meaning of the word should not apply. Why? Because so if you apply the law, the result will be very ridiculous. Why? Because the son, so if you follow the legislation, you follow the literal meaning of the legislation, the son will get all the money of his mother, but he murdered his mother, okay? And he can get all the money. So it will be very ridiculous, okay? But of course, when the legislation was enacted, no one could foresee such a situation, okay? When the legislation was enacted in 1925, if you were one of the legislators, if you ask other people, how about if the son murdered his mother, so what should happen? So I think everyone will be very surprised. Everyone will say, how come a son will murder his mother? Okay? So it's ridiculous. So when the law was enacted in 1925, simply no one can foresee such situation. This is the reason why the legislation did not provide for this situation. Okay? So in this case, the judge said that so if we follow the literal rule, the result will be extremely ridiculous. Okay? So if it's not so reasonable, it's still acceptable. But if the situation is ridiculous, it is unacceptable. This is the reason why the court use the golden rule. The purpose of the golden rule is to avoid ridiculous result. The legislation was very clear on this point. The wording were very clear. So when the mother passed away, all her money, all her asset would be passed to his son. The wording was very clear. But the court held that the defendant was not entitled to inherit because it would be manifestly repugnant to allow a murderer to reap the benefit of his crime. Just like the case when a husband killed his wife. It will be very ridiculous for the husband to get the estate of the wife. Okay, so otherwise, so many people will kill the spouse or kill the parent, etc., in order to get the money. So it's highly undesirable. It's the reason why the defendant could not get the money. Now we move to the third one. The third one is also something quite difficult to understand. Okay, so it's called mischievous. So it's very similar to say golden rule or even the purposive approach. So mischief. Mischief means something bad, means the defect. 一啲唔好嘅一啲缺陷嘅嘢。Okay. So why we use the term mischief? Because you have to realize that so at the very beginning we only have common law. Of course, the common law, of course, is the legal provision which try to cover all the situation. But you have to know that common law was developing in the 12th century. At that time, the society was totally different. When the society has changed so much, what will happen? When the society has changed so much, means that so many things could not be covered by the common law. Okay? You cannot expect the common law to cover so many things. So many things that the common law simply cannot cover. There must be something, okay, the common law did not cover. For example, so in the past, we don't have, we did not have computer. Now we have so many transactions by computer, by internet. We have so many deception cases by computer. Can you expect the common law can cover those things? The answer is no. So you cannot find any common law which cover electronic transaction. Okay? So you cannot find a website under common law. There was no such thing as website or electronic payment under common law. You cannot just use common law because there are so many things not covered by common law. So it's the reason why you need legislation. Okay? So when there's a legislation, usually there must be some reason why the legislation has to be enacted. There must be some mischief, some defect, which the common law did not cover. Okay? You know the background of the legislation. You know what defect the common law did not cover, and then we have the legislation, so you can understand the legislation more easily. Okay? So you use the mischief, the cont, identify some mischief or defect which the common law did not cover. Also, the court has to identify the remedy provided by the legislature. So you have to look at the provision of the legislature and require the court to interpret the legislation to give effect to the remedy. So you know the background, you know the reason for the legislation, you know the defect which the common law did not cover. You can understand the purpose of the legislation. You can understand the meaning of the legislation much more easily. From time to time, in the bill, there's an explanatory memorandum. The government will prepare some explanatory memorandum when they present the bill to the Legislative Council or Parliament. In the memorandum, you will know what were the problems faced by the government. Okay? Usually, the government will only enact legislation when there are some problem which cannot be solved by common law. If the problem can be solved by common law, there's no need for the government to enact any legislation. There must be something not covered by common law. Okay? For example, when you study contract law, you find that the common law does not care whether the exemption clause is reasonable or not. Okay? But as time goes by, you can find so many people use unreasonable exemption clause. They try to exempt all the legal liability. So it's something very unfair to the citizen, to the consumer. This is the reason why the court, why the government passed the Control of Exemption Clauses Ordinance. Why? What's the purpose of this ordinance? The purpose of the ordinance is to control some unreasonable and unfair exemption clause. Okay? So you will know the background, so you can understand the law more easily. It can be illustrated by a case called Smith and Hill. So please go through the case by yourself. I'll give you 1 minute's time. So can you understand this case? vanadium. Of course, I like vanadium. I like the song Whole Line. Okay, so for this case, so you can appreciate the meaning of mischievous. Right. Because in this case, the legislation say that it's an offense for prostitutes to solicit in a street. Of course, so the legislator has some omission. They just use the term in the street. But of course, the prostitute were very clever. What did they do? They did not solicit customer in the street. In order to avoid the legislation, what did they do? So they solicited customer from a window or balcony. So if you use the little the prostitute would not be found guilty because they did not solicit customer in the street. Instead, they solicited a customer from a window or balcony. Okay. So literally speaking, they could avoid, they could make use of the loophole of the legislation, because the legislation only say that it would be an offense if you solicit, say a customer in the street. So when they did it from a window or balcony, so if you use the little they should not be found guilty. But what was the decision of the court? The court held that the mischief that the legislation intended to kill was to clean up the street. Why? Because when the prostitute solicited customer from a window or balcony, it had the same effect. Okay, the problem was simply the same. They could attract a lot of men in the street. They could attract a lot of uncle in the street. Okay, so it's just the same. No matter whether they did it in the street or from a window or balcony. So the effect, the outcome was more or less the same. Okay, and the fact that the prostitute was not physically in the street, but only solicited customer from window or balcony was irrelevant. The effect of their conduct was to promote sexual activity, which was what the legislature had intended to forbid. So you may find that the outcome will be very different if the court used the little rule. So if the little rule, so if the judge used the little rule, what is the outcome? Not guilty. Very good. The prostitute will be found not guilty if the judge used the little rule. Okay. So we can also find this case Smith and Hill. Smith and Hill, 1960. Six women have been convicted under Section 1, Subsection 1 of the Street Offences Act 1959, which stated that it shall be an offense for a common prostitute to loiter or solicit in a street or public place for the purpose of prostitution. In each case, they argue on appeal that they were not in a street or public place as required by the one of the elements is that they must solicit in a street or public place. They argue that they were not in a street or public place. One woman had been in a balcony and other had been at the window of ground floor. With the window either half open or closed. In each case, the women were attracting the attention of men by calling to them or tapping on the window. So the effect was more or less the same. They could attract a lot of men. The court decided they were guilty. For my part, I oppose the method by considering what is the mischief look aimed at by this act. Everybody knows that this was an act to clean up the street, to enable people to walk along the street without being molested or solicited by common prostitute. So it's the purpose of the act, okay, is to clean up the street. So for the action of the prostitute, they will defeat the purpose of the act. So it's the reason why they were found guilty. In our case, Cockery and Covenant, a man was found guilty of being drunk when he was in charge of a carriage, although he was in fact only in charge of a bicycle. So he was guilty of drunk driving, 醉駕. So even though he was only in charge of a bicycle. Okay, I think we have to take a break now. So after the break, we'll go to another more difficult case. It's called purposive approach. We'll look at a landmark case called Medical Council versus Dr. Charles Shek. This is a quite difficult case and quite complicated case. Please take a break for 10 minutes. After the break, we will come back and discuss the purposive approach. Okay, so we'll continue the lecture. So before I start, so I would like to answer some questions. So for example, a student asked me, the woman will give following it when the譬如說兩 cam 算譬如說咧 so ignorance of law is no defense so it's the underlying principle of English law so of course if you are very careful you have to consult the lawyer so when you do something so many people will be found guilty sometimes they do not know what they are doing is something is a criminal offense Hilda so the judgment there in the tree is ambiguous so first of all, principle that so in fact the general principle is that the court has the discretion to decide which approach he's going to use. He has the discretion to decide. So it's only the general legal position. So when we say when there's low ambiguity, usually the court will use the literal rule. Would you please tell me where can I? So I think you can just go to show. You can just load the law. When can the judge decide picking up which rule? There's low fine, low fine strict rule. There's low rule to say that under what circumstances the court should follow which rule. So there's no such thing. The court always has the discretion to decide which approach he's going to use. Also, so usually the judge will indicate which rule he will use in the judgment. In fact, by reading the judgment, you can find out which rule, which approach the court is using. Now we go back to slide 16. We go back to slide 16. So first of all, law need to interpret a provision unless it's ambiguous when viewed in its proper context. Context is a term we have to understand. So context means what's around a word or phrase. So when just like the peers, when you say I will marry you, you have to know the context. If you do not know the context, if I just tell you someone ask me, so just someone tell me, a middle-aged man tell me he will marry me. Of course, it will be very funny. But say so in this way, so you can say that say if you know the context, so you think there's nothing silly. Okay, so it's something very common. However, no legal rule defining context for every situation. Now we can use this one is in fact is a landmark case. It's a very famous case. Medical Council of Hong Kong versus Charles Siu Shek. Charles Siu Shek is a medical doctor. So you can find this case on page 107 of the workbook. So we can now briefly explain the case, the facts of the case. So for Dr. Chow, just like Mr. Yun said on, he was charged by the court for 2 times. So in 1990, defendant Dr. Chow, he was a registered medical practitioner. He was convicted and influenced, punishable with imprisonment. So usually in Hong Kong, for the professional, they are regulated by the own professional body. Just like lawyer, we are regulated by the Law Society or Bar Association. For doctor, they are regulated by the Medical Council, 醫學會. The Medical Council has the power to remove his name from the general register either permanently or for a period of time. So it's something very common sense. Permanently, it means that he is removed, his name is removed forever 永久除牌or for a period of time like 1 year, few year or 3 years is something very common sense so usually the say disciplinary hearing個紀律聆訊discipline hearing so because the professional will be charged with professional misconduct when he was found guilty in a court usually the hearing will be after the court trial so because in the hearing so the doctor will be found guilty or not guilty if he's found guilty usually he will be also be guilty of professional misconduct, right? So his name will be removed for a certain period of time. So in this case, in 1994, you see 1994 was after 1990, okay? So the council removed his name for 3 years. So up to this stage, you cannot find anything wrong. So it's something so usual. So but in another next year, so the defendant was convicted by the court for other offences, just like the case of Mr. Yun said on. He was charged by the government for 2 times. So in the second time, he was also convicted by the court for other offences. Okay? So in the year of 1994, defendant applied for restoration of his name to the register. It means that he want to apply for restoration 申請復牌 okay so for of course just like a prisoner so his name was removed for 3 years so the expiry date should be 1997 so in 1998 the 3-year period has already expired so it's something very usual it's something very normal for him to apply for restoration of his name to the register so that he can resume his medical practice and also earn money. So if you were the friend of Dr. Chow, of course you will be very happy. So you can expect Dr. Chow will be also very happy. He was preparing for resuming the medical practice. He would rent lease a shop for clinic purpose. He would say employ a nurse to be his assistant, etc., etc. Okay. So of course he was prepared to resume his medical practice just like a prisoner. Okay. So when the term of imprisonment is going to expire, the prisoner will expect that he can leave the prison and he can go home. But what happened in this case? So in another section, so section 25, subsection 3, the council may, in its absolute discretion, allow or refuse an application to be restored to the register by a person whose name has been removed. So what does it mean? When you look at section 21, subsection 1, can you find anything wrong? The answer is no. It's something so common sense. The removal either is permanent or for a certain period of time. It's something so common sense. Just like imprisonment. The imprisonment may be life imprisonment or it may be 1 year imprisonment, 3 year imprisonment. So you cannot find anything wrong. Okay? How about section 25, subsection 3? Can you find anything wrong? If you just look at section 25, subsection 3, can you find anything wrong? When you look at section 5, section 25, subsection 3, can you find anything wrong? You cannot find anything wrong. But the problem is, if the council has the discretion to refuse an application, so what does it mean? For example, if the removal is 3 years, on the expiry of the 3-year period, so when the doctor wants to resume his medical practice, the council said, no, sorry. You're not allowed to restore your name to the register. You cannot resume your practice. Just like a prisoner, when the 3-year period is going to expire, the prison officer tell him, sorry, you have to stay in the prison. You're not allowed to leave. Even though the prisoner, so he expects he will go home next month. But the officer told him, sorry, you're not allowed to leave. Okay, you have to stay here. And also, the officer does not tell him how long he has to stay, just like the counsel. The counsel only refuse his application. The counsel does not tell him when he can resume the application. Why? Can you find anything unusual? If you are not careful enough, you just look at Section 75, Subsection 3. If you do not think very carefully, you cannot find anything wrong. Oh, of course, if there's an application, of course, the counsel should have the discretion. The counsel can decide whether to allow or refuse the application. Okay, it is something to common sense. But when you view the two sections together, you will find some ambiguity. Why? Because when you say, your practice will be suspended for 3 years, usually you will expect that on the expiry of the 3-year period, you can resume the practice, just like a prisoner. When he's in prison for 3 years, what will he expect? He will expect that he can leave, at the expiry of the 3-year period. 判3年監你坐夠就走得㗎嘛，係咪？ So if you are not allowed to leave after the 3-year period, of course you will think that is something so ridiculous. When you look at these two sections together, you will find that it may be something ambiguous. So if you follow, if you interpret Section 25, Subsection 3, in this way, and you say you think that the counsel always have the discretion to refuse an application. It is the case. So 3 years, it does not mean 3 years. 3 years may mean 30 years. 3 years may mean forever. Why? Because the counsel can always refuse an application to be restored. It means the prison can always refuse the prisoner to leave. Okay? So what is the position? Does it mean the situation is very ridiculous? So what can you expect? Can you expect Dr. Charles is very happy with the decision of the court or the counsel? Of course, Dr. Charles was very angry. He said no, he appealed. He sued the medical counsel in the court of first instance. He won the case, and then so the counsel appealed to the court of appeal. 2 judges in the court of appeal applied the little rule. They held that there was no ambiguity, and that the defendant, that's the medical counsel, should be automatically entitled to have his name restored to the register at the end of the 3-year period. This had the effect of limiting the counsel's discretion under Section 25, Subsection 3, to cases where the doctor's name was removed indefinitely or where he applied during the period of removal. So if the restoration, we have 2 possible interpretations, just like the case of Yun Sek On. We have 2 possible interpretations. The first one is that the restoration is automatic. So on the expiry of the period, the restoration will be automatic. 即係自動賠款，總之坐夠。So no, as long as the period has expired, for example, the 3-year period, as long as it expired, the restoration will be automatic. This is one of the interpretation. The other interpretation is that the restoration is subject to the discretion of the counsel. Is the standpoint of the counsel. The counsel argued that the restoration must be at the discretion of the counsel. It should not be automatic. Later on, you will know the reason for the say interpretation preferred by the medical counsel. One judge dissented on the ground that to limit Section 25, Section 3 to a small number of cases could lead to manifest public mischief. So he used the golden rule. So now the case was heard in at the end of the day. I can find that the case was heard in the Court of Final Appeal. So In the Court of Final Appeal, it was the outcome of the case in the Court of Final Appeal. Go to slide 22. The Court of Final Appeal unanimously allow the council's appeal. It means that the council won the case at the end of the day. The provision should be read in the context of the whole statute as a purposive unity. You should not just look at a certain subsection of the ordinance. You have to view the whole legislation together as a purposive unity in its appropriate legal context. So it's the reason why we have to consider the context, the surrounding the facts surrounding the legislation, the surrounding fact. Applying the text and reading the two provisions together, Section 25, Subsection 3 was ambiguous. The meaning was ambiguous. Okay, so we have two possible interpretations. The first one is automatic entitlement. It means that the doctor will be entitled to automatic restoration. 即係自動復牌 as long as the period has expired, or subject to the discretion of the medical counsel. Which one will you prefer? If you were the judge, judging from the public policy, which one will you prefer? A or B? So no, we just ignore the legal reasoning. From the angle of public policy, which one will you prefer? A or B? Most students will say B, subject to the discretion of the medical counsel. Please note that for all the rules relating to professional, we have to strike a balance between the right to practice of the professional and also the public interest. Okay, so we have to protect the rights of the professional. Because for lawyer, for say doctor, they have the right to practice their own profession because they have spent so many years in getting the qualification. So if you can suspend the practice without good reason, it would be unfair to them. But we also have to protect the public. Okay, we cannot allow some bad guy to practice, dishonest lawyer, dishonest doctor to practice because it will affect the public interest. So if we just look at the interest of the doctor, so we will prefer A. But if we look at the interest of the society, it should be B. Okay? Why? Later on you will know the reason why the medical counsel refused his application for restoration. So the purpose also in this case, the court adopted the court used the medical approach, the purposive approach to resolve the ambiguity. Medical. Now we go back to slide 35. So the medical purpose, the purposive approach also look for the intention of the legislature, but focuses attention on the purpose or object of the ordinance. So for the mischievous, many students find it difficult to distinguish the mischievous and the purposive approach. In fact, purposive approach is a broader version. The mischievous is a level version. Okay. So the context includes information outside the ordinance. In the past, many judges only look at the wording of the legislation, but now the judge will consider something outside the legislation. Okay, so when you are going to interpret Section 25, Subsection 3, you should not just look at the wording of Section 25, Subsection 3. You also look at some other relevant information. They are called extrinsic. Extrinsic means external. 外部嘅幫助。So there may be some document which will be helpful, which will be useful to find out the the intention or the objective of the ordinance. So when we compare the purposive approach and the mischievous, we can say that mischievous is the level version. Why? Because the mischievous only look at the mischief, not covered by common law. But for the purposive approach, you look at the purpose, the intention of the legislation. So the purposive approach was adopted to resolve the ambiguity in the case of Medical Council of Hong Kong and Charles Hsu said, So in this case, the Court of Appeal, the Court of File Appeal, so the CPA, CFA, consider the following issue. The first one is the court identify the purpose from its long title. You have to know that most legislation has the long title. Usually the long title will state the purpose of the legislation. Okay, this is the purpose of the legislation. You can find out the purpose of the legislation from its long title. Usually the long title is before section 1. It's after the short title, but before section 1. B. Place the ordinance in its appropriate legal and social setting. So the social setting includes the right of a person to practice his or her profession. It's the right of the member. Okay, it's the right of the doctor. It's the right of the lawyer. He has the right to practice because he has spent so many years in getting the professional qualification. So the professional body should not stop him from practicing so without good reason. But we also have to balance the public interest. Why? Because we have to protect the public. We have to protect the citizen. We have to protect them from some bad guy of the profession. So C, identify interpretive consideration and, if necessary, weigh and balance them. First of all, consideration usually it means factor. Just like the case when you are going to buy a computer, you have to identify the factor, the consideration you will you have to identify the factor you will consider. For example, the price of the computer, the brand of the computer, the function of the computer, the model, any after sales service, warranty, etc. These are the factors you will take into consideration. So you have to identify what factor we will take into consideration. And also we have to weigh and balance them. We have some factor may be more important. Some factor may be less important. Okay. But we have to strike a balance. Because some of them they are conflicting. For example, you are going to buy a computer. Of course, you don't want to pay so much money, but the price sometimes is in conflict with the quality. Some very good computer may be more expensive. Some are not so expensive, but the quality is very doubtful. So you have to strike a balance between the price and also the quality. Okay. For this consideration, so we have to go through them one by one. First of all, you have to strike a balance between conflicting purpose. Okay. Of course, it's something very common sense. From time to time, no matter what decision we take, we have to strike a balance between conflicting purposes. Okay. For example, you want to be absolutely safe, you have to stay home every day. If you stay home, usually you are very safe. You will not be in trouble. If you stay home, usually you are 100% safe. Okay? But of course, you have to earn money. You have to go out to meet your friend. So you have to strike a balance between these two conflicting purposes. Okay? So number two, statute dealing with similar area. When we are going to examine the ordinance, we have to refer to some similar ordinance. So for the medical council, the most similar ordinance is the dentist. Because doctor, so the job is more or less the same. It's very similar. The job nature of doctor is very similar to dentist. So we have to refer to the dentist registration ordinance. Usually they will have the same purpose or similar purpose. Okay. So number three, the law's tendency to avoid circularity. This one is quite difficult to understand. Can you guess what does it mean? The law tendency to avoid circularity. What does it mean? Can anyone guess what is meant by the law's tendency to avoid circularity? This one is quite difficult. I think you may have to refer to the full case before you can understand. So I can give you a very brief, explanation. Please note that the facts of the case. So we go back to the facts of the case. In 1998, when he applied for restoration of his name to the register, what happened? What happened is that so he was already convicted by the court for other offenses. The disciplinary hearing for this offense, for the offense in 1995, in fact, there was not yet any disciplinary hearing for the offense in 1995. Of course, what can you expect? If there was a disciplinary hearing for the offenses in 1995, what will happen? What will happen is that the defendant will be removed from register for another period of time. It's something very, very certain. 因為你已經坐監啦，你再出嚟紀律程序通常又係衰一次啊嘛，係咪？So of course, Dr. Chow argued that you should restore my application, and then you take a disciplinary hearing. You find that I was guilty of some professional misconduct, so then you should suspend my practice for another period of time. But of course, this argument was not accepted by the medical council. We call it circularity. Circularity means that so for Dr. Chow, he argued that you should restore my name, and then you say in the disciplinary hearing, if you found them I was guilty of professional misconduct, and then you should remove me. 你應該復咗我牌，復咗我牌就紀律聆訊，有咩事你再除我牌咯。Of course, this argument was not accepted by the medical council, and also it was not accepted by the court. Why? Because it will cause a lot of confusion to the public. Okay, so when Dr. Chow's name was restored and then he was removed 1 year later, it will be highly ridiculous. 就復牌，跟住1年後就除牌，咁啲公眾都覺得好混亂。Okay, so the citizen, the patient will be very confused. How come say a doctor's name was restored and then he was removed just 1 year later? It will cause a lot of confusion. But of course, from the angle of Dr. Chow, he will prefer it. At least he can practice his profession for 1 year. It will be better than nothing. Also, the number 4 is the law's tendency to construe all provision of statute in such a way as to give effect to each provision. So it means that we will not just focus on one single provision. Okay? So all the provision should be construed in a collective manner. And also number 5, presumption against medical change in the law indirectly. It's also a quite important concept. Because if the court interpret the law so in a very different way from what most people think, so it may amount to amendment in law. Okay, 釋法會相等於修法修改法律So if the government want to amend the law, so the government should go through the process of legislation. So go through the necessary legislative process. The government should not use interpretation of law to replace amendment of law. So it's something highly undesirable. The court should try to find the true meaning of the legislation instead of amending the legislation. Amending the legislation is not the job of the judge. Okay? It's not the job of the judge. The job should be left to the legislature. That's the legislative council. But in this case, all the factors point to the same direction. Each of these factors operated against the right of a doctor to have his name automatically restored to the register. It will be something quite dangerous, just like even for a prisoner. So if a prisoner is in prison for 3 years, does it necessarily mean that he can leave the prison on the expiry of the 3-year period? The answer is no. Why? Because if the prisoner was fighting with other, killing other people, or say trafficking drug, or doing so many big things during the 3-year period, do you think he can leave the prison on the expiry of the 3-year period? The answer would be no. Okay? So usually he can leave if he's well behaved, but if he's not so well behaved, if he has committed a lot of wrongs, usually he will not be allowed to leave, even though the 3-year period has already expired. If the restoration is subject to the discretion of the medical counsel, it will be more reasonable because the medical counsel can take into account so many factors, okay, during that 3-year period. For example, if a doctor is removed from register, but during the 3 year, he is still selling illegal drug. So for this case, the offenses committed by Dr. Chow was selling some illegal drugs. 就買啲丸仔because for some doctor, because some doctor, I think because they want to get more money, so they are selling some kind of drug. So it's something quite common for some doctor, because especially to those who want to earn more money. So I think usually on the application for restoration, the medical counsel will take so many things into consideration, including the behavior, the conduct of the doctor during the period. Court may adopt different approaches to determining whether there's a need for a statutory interpretation with different results. This is possible because there's no legal rule which requires judges to apply one particular approach. The judge can choose either one. There's no rule to dictate which approach has to be used by the judge. It may be little rule, extreme rule, golden rule, or purposive approach. Either one. But purposive approach is the most modern approach. Now most judges will use the purposive rule. And if the wording are very clear, usually they will use the little rule. But in case of ambiguity, the judge will use the purposive approach. This is the modern approach. Now most judges will use the purposive approach instead of the mischief rule. And then we will look at the extrinsic A. Extrinsic A means something outside the legislation. Okay? In the past, the judge will only look at the legislation, the relevant section, to find out the meaning of the legislation. But now they will consider something outside the legislation. So it's called extrinsic A to construction. Extrinsic means operating from outside. Extrinsic A means material outside the statute or ordinance which may be viewed to ascertain the mischief the legislation was seeking to remedy. So there's so many examples like report or proceeding. In Hong Kong, the Legislative Council will have a lot of meetings. All the meetings, there will be record of the meeting. So the document is called Hansard. In fact, it is the minutes, is the record of the proceeding, record of the meeting held by the Legislative Council. And also bills. For the bills, usually there will be explanatory statement. The government will prepare the explanatory statement to explain the reason why they want to enact the bill. Hansard means official report or proceeding in Parliament. You can find those Hansard in the website of the Legislative Council. In the past, the court had used the exclusionary rule. Exclusionary rule means such material may not be used by the court for the purpose of ascertaining the meaning intended to be given to the verbs in use. So now the rule has already been relaxed under the condition laid down by the House of Law in a case called Pepper and Hart. Usually when you study law, you find that the law usually was very strict, very simple in the past. But as time goes by, so there will be more and more exception to the general rule. So when you study law, you'll find that many rules they are only general rule. General rule means that they are genuinely true, but they are not absolute rule. Don't think that they are absolute. There will be exception to the general rule. But all the exception must be recognized by law. You cannot set an exception by yourself. Okay, so you are not the judge. So for the exception, they must be recognized by the law, usually in the judgment. So you cannot add any exception by yourself. You cannot say, oh, it's an exception. So all the exception must be recognized by law. For example, in the gambling ordinance, so gambling ordinance say that gambling in Hong Kong is illegal. 賭博條例話賭博係非法。In Hong Kong, in general, gambling is illegal. But the general rule is subject to so many exceptions. Okay? Of course, the activity you are doing must fall within the exception. So you are doing something not fall within the exception to the general rule, so you will be guilty of gambling. There are so many exceptions to the general rule, but they have to be listed in the gambling ordinance. For those exceptions, so there are three conditions for the some conditions for the exception. Under the case of Pepper and Hart, the exclusionary rule should be relaxed where legislation is ambiguous or obscure or leads to an absurdity. And also the material relied upon consists of one or more statements by a minister or other promoter of the bill. And also the statement relied upon are clear. Usually only explanatory, notes or some policy paper will be relied upon by the judge. You cannot just cite an article in the newspaper. You cannot just cite an article in the magazine. Usually, because there are simply so many articles, so much material relating to the legislation. For example, when we have a new legislation, so many people will comment on the legislation. So usually, you simply cannot cite those comments because they are not authoritative. They are not from the government official. So they cannot be relied upon. So if the judge can can refer to any material, so the situation will be very confusing. So the judge, even though the judge is willing to relax the exclusionary rule, there must be some condition under which we can relax the exclusionary rule. So the exception must be limited. You cannot extend the exception to a very big extent. So I think on page 112, you can find those interpretation, consideration. Identify the party, so you have to find the purpose of the medical registration ordinance from its long title. The purpose is to consolidate and amend the law by making more comprehensive provision regulating the registration of practitioner in medicine and surgery. He filed the judgment. In this case, the judgment was delivered by Justice Bookery. He referred to specific provision in the ordinance which show that the purpose of the ordinance concern more than just competence and qualification to practice as a doctor. Okay? So of course, one of the purpose of the ordinance is to protect the public. Number 2, place the ordinance in its appropriate legal and social setting. On the one hand, you have to protect the rights of a person to practice his profession. On the other hand, you have to protect the public interest in integrity. So we have two conflicting purposes. Okay? The court was entitled to assume that statutes are intended to be for the public good. Okay? So you have to maintain the integrity of the medical profession is also for the public good. Number 3, identify interpretive consideration and weigh and balance them. So these are the 5 interpretive considerations. In the conclusion, the court held that each of these factors operated against the right of a doctor to have his name automatically restored to the register. So it means that all the factors point to the conclusion that the restoration should be at the discretion of the medical council. Because the medical council was formed by so many doctors, so all the council members, they were representative of the profession. They are doctor of very high integrity, very long working experience. So they have very good standing in the society. So the decision should be more reliable. So if the court allow automatic restoration, it will be very dangerous. So it's the landmark case for for purposive approach. So please make sure that you are very familiar with this case. So we can also see the judgment of medical council and child suicide. So it's a CFA case. Okay. So it's a civil appeal. So we have the CFI, CFI, and also CA, and also CFA. Altogether, we have 5 judges. Justice Lee, Litton, Ching, Bookery, and also Mason. But in Hong Kong, the most embarrassing thing is that in Hong Kong, many Chinese, they have the same surname. For example, Lee, Chen, Wong. So sometimes, but in England, usually people, not so many people will have the same surname. But in Hong Kong, so it's quite embarrassing because so many judges are called have the same surname. So when you say Judge Lee, Judge Wong, you do not know which one you are talking about. But the practice is to just to mention the surname. For example, Justice Lee, Justice Ching. Okay? So usually we will not mention the full name of the judge. Just like Lord Denning, we just know that his surname is Denning. Okay, so usually not so many people will mention his first name. So for this one, so the judgment was delivered by Justice Bookery. For other judges, the job is very simple. They only say, "I agree with the judgment of Mr. Justice Bookery, PJ." So section 21.1 and also section 25.3. Subsection 3. So Deutscher, he was convicted for 2 times. So it's mainly selling dangerous good, dangerous drug. 買啲危險嘅藥物because so the doctor could earn a lot of money by selling dangerous drug. Of course, the judge will refer to a lot of precedent case in order to find out the true meaning of the legislation. So you find that so altogether we have so a lot of interpretive consideration. So the concept I reject the notion of automatic entitlement or to restoration. I hold that all registered medical capacity they have been removed are covered by Section 25, Subsection 3. So it means that all the restoration, all the application for restoration must be at the discretion of the medical council. So at the end of the day, the outcome is that the court would allow the council's appeal. So to dismiss Dr. Charles' application for judicial review. So we also mentioned the term judicial review. Please note that judicial review, it does not only apply to government, but also to many public body. So including university, the medical council, or law society. When those professional body or university have made a wrong decision, say the applicant or any people concerned can also take a judicial review. So it's the landmark case. So you may consider to say print out this judgment for reference purpose. So it's something very say interesting. So please try to say go through a full case to see whether you can understand the judgment. You have to learn how to understand the judgment by yourself because in the future you will come across many cases. So try to learn how to understand the judgment by yourself. Now please do the revision question. I'll give you 5 minutes time and then we'll go through the answer. These are the important or the major points for this chapter, for this lesson. So now we can go through the answer. Question 1, Section 19 of Cap 1, Interpretation and General Clauses Order. It may be regarded as the first principle of interpretation. Even though Section 19 may not be too useful, because the meaning is not so clear, and also is not so useful. But you still have to mention Section 19 in your answer in the examination. Because for marking the answer, so usually we will count so how many points you have mentioned. So if you do not mention this point, you may lose 2 marks. So you have to mention this part. So the second one is literal approach. It's also called the grammatical approach. 字面法規 because you look at the words of the statute and nothing else to see if there's any ambiguity. Literal rule was very popular in the past because in the past the court was reluctant to ascertain the intention of the legislation. Because to ascertain the intention of the legislation would be something more time consuming. You have to consider so many things. Okay? But for the literal approach, you just look at the wording of the section. For example, Section 25, Subsection 3. So it's something quite easy. So you can also spend save a lot of time, save a lot of energy. So it's the reason why in the past the court usually used the literal approach, especially if there's no ambiguity. So number 3, under the literal approach, if there's no ambiguity, the verb used must be given the ordinary and natural meaning. So we cannot use some unusual meaning, even if this leads to absurdity. Even the result may be quite unreasonable, or there may be some unforeseen consequence. Number 4, for the golden rule, court's duty is to give effect to the intention of the legislature, where the application of the literal rule will lead to absurd or repugnant consequence. It means something very ridiculous. Number 5, the mischief rule identifies some mischief or defect which the common law did not cover. So don't think that so many students have the misunderstanding. They always think that, oh no, it's because the common law has mischief. Not because the common law has mischief, just because some mischief not covered by the common law. Just like the law, even for legislation, don't think that the law can cover everything. There's so many things not covered by the law. Okay? For example, if someone is impolite to you, do you think you can use any law to solve this problem? The answer is no. The law will not cover this situation. Number 6, the purpose approach also look for the intention of the legislature, but focus attention on the purpose or object of the ordinance. So it's the difference between the mischief rule and also the purposive approach. Purposive approach is broader than the mischief rule. The mischief rule only look at the mischief or defect which the common law did not cover. Many legislation, they have nothing to do with the common law, so they are not so related to common law. They were not going to, the purpose of those legislation was not going to cover the defect which the common law did not cover. True and false. Number 1, statutory interpretation is a process by which the lawyer determines the meaning of the statutory provision. So of course the answer should be false, because the job will be done by the judge instead of the lawyer. Number 2, the meaning of verbs or phrases is often clear. Again, it's also false, because from time to time the meaning may not be so clear. Number 3, the literal approach look at the verbs or verbal expression of the statute and nothing else to see if there's any ambiguity. The answer should be yes. Is the correct meaning of the literal rule. Number 5, extrinsic A means material outside the statute or ordinance which may be viewed to ascertain the mischief the legislation was seeking to remedy. Again, the answer should be yes. For MC, who can make delegated legislation? out of the four, it should be the executive officer, including the executive chief executive, Carrie Lam, and also some government senior officer, like the the head of the policy bureau. Number two, who interpret statute, it should be the judges. It's always the job of the judge to interpret statute. Only the judge can interpret statute. So the interpretation of the judge is the most authoritative. So from time to time, you see that in Hong Kong, the government, when they are explaining the law, usually they will use a soft approach. So they do not emphasize that is the correct approach, the correct explanation of the law. So from time to time, in the leaflet published by the government, they always remind the reader to consult lawyer in case of ambiguity, in case of query, because the explanation of the government may not be so authoritative. So the situation is very different from mainland. Because in mainland, the government officials have the authority to explain the law. But in Hong Kong, usually the government the official, they will not be so authoritative. They always ask the people to consult the lawyer. I think for today's lesson, I think we may have to end the lecture a little bit earlier. So in the next lesson, we'll go to chapter 7. Chapter 7 is about court system and also jury. So in the next lesson, so you will do the job of a lawyer. So in the activity in the next lesson, I will give you a case. I will give you a judgment, and then you have to answer some question. So the activity is a little bit different from Yun Sek On. Because in the case of Yun Sek On, you only have to answer a question relating to the case. You have to identify the issue. But in the next lesson, you will be given a case. And then you have to go through the case and answer a problem type question. You have to give advice to the client. So your advice will be based on the case. So of course, as a lawyer, when you come across a problem, so you have to do legal research, you have to find out the relevant legislation or cases. But now the job is done by me. Part of the job is done by me. I already found out the case and relevant legislation. So your job is very simple. Just go through the case and advise the client. Sometimes it's not easy. I don't think that the job is very easy, because when you're reading a judgment, you have to go through every paragraph. You cannot omit something important. Sometimes your advice is wrong just because you have overlooked something in the judgment. Okay? So it's also a very meaningful activity, because you can experience what the job of a lawyer look like. So if you want to be a lawyer, so you have to get used to the life of a lawyer. You have to go through a lot of documents. So you have to be very attentive. You have to be very careful in examining the wording of the judgment. Okay, and also a lot of legal document. Okay. So that's all for today's lesson. So next week, on Tuesday, we'll cover Chapter 7, Court and Tribunal, and then for next Thursday, I will jump to Chapter 9. Because Chapters 8 is very short. We just need half a lesson to cover Chapter 8. So next Thursday, we will cover legal profession, and then the other Tuesday we'll cover legal aid, and then the last lesson we'll cover Chapter 8, ADL, and also we'll do a very simple final revision, and then we'll end our teaching. Okay, thank you very much for attending the lecture. If you have any question, please type your question in the chat room. Thank you very much. You may leave now. If you want to ask any question, please type your question on the chat room. In fact, I want to see you. So I want to see what you look like. So today you have seen my photo. Look cheap and said HKLII. I think not so many people will use this one. I know this one I think is quite useful for law in other countries. For example, the law in England, the law in Canada, the law in Australia. It's something international. But for Hong Kong law, I think not so many people will do this.